Before we begin, a quick and important disclaimer. I am not an attorney, and this video is for educational and informational purposes only. It does not constitute legal advice, and it does not create an attorney-client relationship. Every creative situation is unique, and you should always consult with a qualified legal professional in your jurisdiction for advice on your specific circumstances. Imagine this. You've just done it. You've created the perfect piece of content. Maybe it's a song with a hook so infectious it's being hummed in grocery stores from California to Maine. Maybe it's a short film, a script, a digital painting, a viral dance, your masterpiece. It explodes. Millions of views, shares, comments. You are, for all intents and purposes, a star. Your phone is ringing off the hook. Brands want to work with you. A record label, a publisher, a studio, they're calling. They send you a contract. It's thick 50 pages of dense text, but at the end of it is a number with a lot of zeros. This is it. The dream. You sign. And 6 months later, the dream is a nightmare. You find out you don't own your own song anymore. You discover you've signed away the rights to any sequels for your film. For pennies. You realize that viral dance you created? A massive corporation is now using it in a Super Bowl commercial, and you're not seeing a single dime. You've been creatively shackled, financially gutted, and legally outmaneuvered. This isn't a scare tactic. This is the silent, heartbreaking reality for thousands of talented artists and creators in the United States every single year. The single most expensive mistake you can make in your creative career has nothing to do with buying the wrong equipment or missing a trend. It's signing a piece of paper. It's agreeing to a deal without understanding the labyrinth of legalese designed, more often than not, to benefit everyone but you. So how do you navigate this minefield? How do you turn your talent into a sustainable long-term career without getting eaten alive? The answer isn't a secret formula or a magic bullet. It's a person, a specialist, your secret weapon, the entertainment lawyer. In this video, we are going to pull back the curtain on one of the most misunderstood but critical roles in the entire creative industry. We are going to demystify the world of entertainment law. Forget the boring, dry lectures. We're going to arm you with the actionable knowledge you need to protect your work, your career, and your future. We'll break down exactly what these lawyers do, the 5 critical moments you absolutely must hire one, and how they become the shield that stands between your creative genius and the predatory forces that exist in this business. This isn't just about avoiding disaster. It's about building an empire on a solid foundation. So let's start with the absolute bedrock of your entire creative existence. Your intellectual property. Your IP. This sounds like a complicated corporate term, but it's incredibly simple. It's the stuff you create. The song you wrote, the photo you took, the code you programmed, the manuscript you bled over. In the eyes of US law, when you create an original work and fix it in a tangible medium, meaning you've recorded it, written it down, saved the file, you have created a copyright. Think of it like this: you just built a house. The idea for the house was just floating around in your head. But the moment you put up the frame, laid the foundation, and put a roof on it, you created a physical asset. A copyright is the deed to your creative house. It is the legal proof of ownership. It grants you a bundle of exclusive rights. The right to reproduce the work, to distribute it, to perform it publicly, and to create derivative works like a sequel, a remix, or a movie adaptation. Without this deed, you own nothing. Your masterpiece is just a house built on someone else's land, and they can kick you out at any moment. Here's where the first, and perhaps most fundamental, role of an entertainment lawyer comes in. They are your property managers, your title office, your security guards. The first thing a good lawyer will do is ensure your copyright is formally registered with the U.S. Copyright Office. Why is this so important? Isn't it automatic? Yes, copyright exists the moment you create the work, but registering it is like filing the deed to your house at the county courthouse. It puts the entire world on notice that this is your property. More importantly, you cannot sue someone for copyright infringement in federal court unless your copyright is registered. Let that sink in. Someone could steal your song, put it in a movie, and make millions of dollars, and if you haven't registered your copyright, your ability to fight back and claim what is rightfully yours is severely, catastrophically limited. You might be able to get them to stop, but recovering significant damages? That becomes incredibly difficult. Registration is your ticket to the courthouse. It's the key that unlocks your power to legally defend your work. A lawyer handles this entire process, ensuring it's done correctly, and that the scope of your copyright claim is as broad and protective as possible. They make sure the deed to your house covers not just the building, but the landscaping, the driveway, and the swimming pool. Now, let's say someone does infringe on your work. Let's say a big clothing brand rips off your graphic design and slaps it on a t-shirt, selling it in thousands of stores. What happens next? This is where your lawyer switches from architect to warrior. They draft and send what's called a cease and desist letter. This isn't just an angry email. It's a formal legal demand, a shot across the bow that says, "We know what you're doing. You are infringing on our client's federally registered copyright. Stop immediately, recall all infringing products, and provide us with an accounting of all the profits you've made from my client's work, because we're coming to collect." Often, a powerful, well-drafted letter from a reputable entertainment law firm is enough to solve the problem. The company knows you're serious. They know you have the legal firepower to back up your claim. They'll pull the product, and their lawyers will call your lawyer to negotiate a settlement. You get paid for the unauthorized use of your work, and you never even have to step foot in a courtroom. But what if they don't stop? What if they ignore you? Then your lawyer litigates. They file the lawsuit. They take the fight to the infringer and argue on your behalf to not only stop the infringement, but to win you statutory damages, which can be up to $150,000 per infringement, plus your attorney's fees. This is the power of a registered copyright and a skilled lawyer. It turns you from a helpless victim into a formidable opponent. But protection is only half the game. The other half is profit. Your intellectual property isn't just something to be guarded. It's an asset to be monetized. This is where licensing comes in. A license is simply legal permission for someone else to use your copyrighted work in a specific way, for a specific period of time, in exchange for money. A movie studio wants to use your song in a film. A television show wants to feature your photograph. A video game developer wants to sample a beat you made. Each one of these requires a different, highly specific license. An entertainment lawyer is the architect of these deals. They negotiate the terms. Is it an exclusive license, meaning only they can use it? Or non-exclusive? What's the territory? Is it just for use in the United States or worldwide? For how long? 1 year? Or in perpetuity, meaning forever? And most importantly, how are you getting paid? Is it a one-time flat fee, also known as a buyout? Or is it a royalty, where you get a percentage of the revenue generated? A lawyer fights to get you the best possible terms, ensuring you're not giving away the keys to your kingdom for a handful of magic beans. They know the industry standards. They know what a song placement in a Netflix show is worth. They know what a reasonable royalty rate for a book is. They prevent you from leaving life-changing money on the table simply because you didn't know what to ask for. Owning your copyright is the first step. Registering it gives you power. And having a lawyer to both defend and monetize, it is what transforms you from a starving artist into a thriving creative entrepreneur. It is the absolute foundation upon which every successful creative career in America is built. But this is just the beginning. Securing your IP is one thing. What happens when you're invited to join forces with others? When a record label, a publisher, or a production company slides that 50-page document across the table. That document, the contract, is where careers are made, and where they are permanently broken. And let's be honest, when you're a teenager with a guitar and a dream, that 50-page document looks less like a legal minefield and more like a golden ticket. It's validation. It's the proof that all those nights spent writing lyrics in your bedroom, all those open mic nights playing to a half-empty bar, all of it was worth it. Someone in a suit believes in you, and they're willing to put millions of dollars behind that belief. What could possibly go wrong? To answer that, we need to talk about a 15-year-old songwriter from Pennsylvania who had just moved to Nashville. Her name was Taylor Swift. In 2005, a brand new record label called Big Machine Records, run by a man named Scott Borchetta, saw her talent. He offered her a deal. It was the dream. A 6-album deal. A real-life record contract. She and her family reviewed it, and she signed on the dotted line. And for the next decade, that partnership created one of the most explosive success stories in music history. Hit after hit, stadium tour after stadium tour. It was perfect. Until it wasn't. The problem wasn't buried in some obscure subsection on page 42. It was hiding in plain sight in the most fundamental part of the deal. It's a concept that every single creator, whether you're a musician, a filmmaker, a YouTuber, or an author, needs to understand like the back of your hand. The difference between the song and the recording of the song. Think of it like this. Imagine you're a brilliant architect. You design a revolutionary new skyscraper. The blueprint, the architectural drawing, is your creation. The specific combination of lines, measurements, and materials, that's your intellectual property. In music, this is called the publishing. It's the melody, the lyrics, the harmony. It's the song as it exists on a piece of sheet music or in your head. Taylor Swift, as the songwriter, owned her publishing. Now, a big developer comes along. They love your blueprint. They say, we're going to spend $500 million to actually build this skyscraper. We'll hire the crew, buy the steel, pour the concrete. The final physical building that gets built from your blueprint? That's the master recording in music. It's the specific finished audio file of the song that you hear on Spotify or the radio. It's the result of the studio time, the producers, the session musicians, the mixing engineers, all the things the record label pays for. And in that 2005 contract, like in almost every standard record deal for a new artist, the label Big Machine owned the masters. They owned the finished building, not the blueprint. For a young artist, this seems like a fair trade. You don't have $1 million to record an album and market it to the world. They do. So they pay for everything, and in exchange they own the final product. It's the cost of entry. It's standard. But here's where the standard deal becomes a trap. Ownership is forever. The label owned the masters to her first 6 albums. Fearless, Speak Now, Red, Star 1989 Star. These weren't just albums. They were her teenage diaries, her public heartbreaks, her entire journey to global superstardom, captured in audio. And she didn't own them. This is the first and perhaps most critical job of an entertainment lawyer, to fight the definition of standard. A good lawyer in 2005, sitting across the table from a 15-year-old Taylor and her family, would have known they couldn't win the master rights argument. No new artist gets to own their masters on a major label deal. It's a non-starter. The label is putting up all the risk capital. They're going to demand ownership of the asset they're creating. But a great lawyer doesn't just accept the no. They negotiate around it. They would have said, okay, you can own the masters. For a while, they would have fought to insert something called a reversion clause. A reversion clause is a ticking clock. It's a paragraph in the contract that says after a certain period of time, say 20 years or 35 years, or after the label has recouped its investment plus a certain amount of profit, the ownership of the masters reverts back to the artist. It's a long-term play. It acknowledges the label's initial risk and rewards them for it. But it ensures that the artist, the person who bled for that art, eventually gets to own their life's work. It protects them from a future they can't possibly predict. And Taylor Swift's future was about to take a turn she never could have predicted. In 2019, Scott Borchetta sold Big Machine Records for a reported $300 million. And the buyer was a company owned by a man named Scooter Braun. For context, Scooter Braun was the manager of Kanye West, an artist with whom Swift had a very public and very painful history. Suddenly, her entire back catalog, the audio recordings of her youth, were the legal property of a man she considered a bully and an adversary. He could license those songs for commercials she didn't approve of. He could release greatest hits collections without her permission. He controlled her legacy. Her art was now just an asset on someone else's balance sheet. This is the ultimate nightmare for any creator. It's the moment you realize that the golden ticket you signed years ago was actually a cage. But this is where the story gets brilliant, and it hinges on that crucial distinction we talked about earlier. They owned the building, the master recordings, but she still owned the blueprint, the publishing rights to the songs themselves. So what did she do? Guided by a world-class legal team, she found a loophole. Or rather, she used the rights she did have to launch one of the most audacious power plays in music history. She announced she was going back into the studio to re-record her first 6 albums, note for note. Why was this legally possible? Because she, as the owner of the publishing, could grant herself a license to create a new cover of her own song. She was essentially covering herself. The result? Taylor's version. These new recordings are almost identical to the originals, but with one critical difference. She owns these new masters completely. She then leveraged her incredible connection with her fanbase, asking them to only stream and buy Taylor's version. This move devalued the original masters owned by Scooter Braun's company overnight. Why would a movie studio pay a fortune to license the original Love Story, when they could license the new, artist-approved Love Story, Taylor's version, for a better price, and support the artist directly? She couldn't take back the old building, so she built an identical one right next door and moved all the tenants over. This story is a masterclass in creative lawyering and the power of ownership. But it's a cautionary tale that started with a standard contract signed by a teenager. A single clause, a reversion clause, could have changed everything. It could have given her a light at the end of the tunnel, a date on the calendar when her work would come back to her, without having to resort to such a monumental undertaking. The lesson here is profound. When you create something, you create two things: the idea and the tangible expression of that idea. The manuscript and the published book. The film script and the finished movie. The raw video files and the final YouTube upload. The contract is the document that decides who controls what. It dictates who gets to profit from your work, not just today but for decades to come. An entertainment lawyer isn't just checking for typos. They are a strategist, a fortune teller, fighting for your future self who doesn't even exist yet. They are fighting for the 30-year-old artist you will become, protecting them from the eager 15-year-old you are today. The battle against a giant corporation like a record label is one of the most obvious places a creator needs protection. But the threats to your career aren't always external. Sometimes the most devastating conflicts, the ones that tear creative projects and lifelong dreams apart, come from the inside. They come from the person sitting right next to you on the tour bus, your co-founder, your bandmate. It's the story we've seen a million times. The garage band that conquers the world, only to be conquered by their own success. The two YouTubers who build an empire from a spare bedroom, only to tear it all down in a bitter public feud. It's the creative equivalent of a civil war, and it's almost always preventable. The problem starts with the best of intentions, starts with passion. When you and your friends are just starting out, huddled in a basement writing your first songs, or scripting your first video, the last thing on your mind is legal paperwork. You're a unit, a family. You're all in it for the art. You think, we'll just split everything equally. We trust each other. That single, simple, and incredibly dangerous assumption is the seed of future disaster. Let's imagine a band. We'll call them Faded Echo. For friends, inseparable. They write incredible music. The singer has a voice that can stop traffic, and the guitarist writes riffs that are pure magic. The rhythm section, the bass and drums, are the solid, reliable engine. In the beginning, everything is a collective effort. They finish each other's musical sentences. They get a little local buzz, then a manager, then a small indie record deal. Their first single starts getting some real traction, and that's when the trouble starts. It's subtle at first. The hit single. Who really wrote it? The singer came up with the lyrics and the melody in the shower one morning. But the guitarist created that unforgettable, iconic guitar hook that makes the song what it is. The drummer added a beat that completely changed the feel from a slow ballad to an anthem. The bassist locked it all together. So, when the first royalty check comes in, who gets what? They agreed to split everything 4 ways. But the singer starts thinking, wait, that was my melody, my words. Without me, it's just a riff. The guitarist thinks, without my hook, it's just another generic pop song. The unspoken resentments begin to fester. Then comes the next level of success. They're on tour. The singer is the face of the band. He does most of the interviews. The media starts referring to the band as him and his backup. He starts getting offers for solo features on other artists' tracks. He wants to explore it, but the rest of the band sees it as a betrayal. We're a unit, they say. You can't do that. But was that ever actually written down? Was it ever a rule? The final blow comes when a major label offers the singer a massive solo contract, with the option to bring the rest of the band on as his hired musicians. The friendship shatters. The singer wants to leave, but he wants to perform all the Faded Echo songs he wrote. The rest of the band is furious. They want to continue as Faded Echo with the new singer. But who actually owns the name? The drummer, who came up with it years ago? Or the band as a legal entity? The problem is, there is no legal entity. There's just 4 guys who thought their friendship was stronger than any contract. Now they're not talking to each other. They're talking through their lawyers. They end up spending hundreds of thousands of dollars suing each other over the name, over songwriting credits, over master recordings. The band is dead. The friendship is gone. And their creative legacy is forever tainted by a bitter public fight that could have been avoided with a single document: the partnership agreement. For a band, it's called a band agreement. For a YouTube duo, it's an operating agreement. It's a prenup for your creative marriage. And it is the single most important document a collaborative group can create. An entertainment lawyer's job here is not to create conflict. It's to anticipate it. They sit the band down in that honeymoon phase and force them to have the awkward, difficult conversations while they still like each other. They go through the what-ifs that no one wants to think about. The first and most crucial question: the name. Who owns the trademark to the band's name? Is it owned equally by the founding members? What happens if a member leaves? Can they use the name? Can the remaining members continue without them? A good agreement will lay this out in black and white. For example, it might state that the name is owned by the partnership, and if the partnership dissolves, no one can use it. Or it might state that any two or more founding members continuing to perform together have the right to the name. This single clause could have saved bands like Pink Floyd or Guns N' Roses years of legal headaches and millions of dollars. Next, and just as explosive, is songwriting and copyright. The lawyer will ask, how are we splitting the songwriting credits? The default under U.S. copyright law is that all co-authors own an equal share, unless they agree otherwise. But is that fair if one person is the primary writer? The agreement can specify different splits for different songs, can create a formula. Maybe lyrics are worth 50% and the music is worth 50%, and you divide the music portion among those who contributed. It forces the band to define what writing a song actually means to them. Before a song is worth $1 million. Then there's money and assets. Who owns the gear? If the band breaks up, does the guitarist get to keep the tour van he bought with his own money, even though the whole band used it? How are profits and losses shared? The agreement defines the business of the band. It outlines who can sign contracts on behalf of the group, how banking is handled, and how major decisions are made. Is it a majority vote? Or does it have to be unanimous? Giving one person, like the founder, a tie-breaking vote can prevent creative gridlock down the line. And finally, the most important clause of all, the leaving member provision. This is the divorce settlement. What happens when someone quits or, even more awkwardly, is fired? The agreement needs to spell it out. Is the leaving member bought out of their share of the partnership? How is that value calculated? Do they retain their songwriting royalties for songs they co-wrote? Absolutely. But do they get a share of future record sales or merchandise featuring their face? The agreement determines this. It creates a clean, professional process for separation, preventing a messy, emotional implosion. This isn't just for rock bands. This is for the two podcast hosts who have a viral hit. Who owns the show's intellectual property? The name? The back catalog of episodes? What if one wants to take on a sponsor the other hates? This is for the filmmaking collective, the dance troupe, the YouTube group. Anytime you create something of value with other people, you have formed a business partnership, whether you have a piece of paper or not. The law will see you as a partnership. The question is, will it be a partnership governed by the state's default rules, or one governed by rules you created for yourselves? An entertainment lawyer in this situation acts as a combination of therapist, business consultant, and fortune teller. They have seen this exact movie play out 100 times before, and they know how it ends. By forcing you to confront the worst-case scenarios up front, they protect not just your future income, but your friendships. They build a container for your creativity, a structure of rules that allows the art to flourish without being destroyed by the business. It's about replacing vague assumptions with clear agreements. This internal foundation is everything. It is the bedrock upon which your entire career will be built. Because once your house is in order, once you are protected from yourselves, you then have to face the outside world. You have to face the labels, the studios, the publishers, and the gatekeepers. And that requires a whole different level of armor, starting with the most legendary, most feared, and most misunderstood contract in the entire creative world. The one that can make you a superstar, or leave you in debt for the rest of your life. I'm talking about the major label record deal. For 100 years, this was the golden ticket. The one-way pass from your garage to the Grammys. It's the contract that built empires for companies like Columbia, Atlantic, and Capitol Records. It's the document that artists dreamed of signing. The one that meant limousines, screaming fans, and your face on the cover of Rolling Stone. But baked into the very DNA of this legendary agreement is a series of traps so brilliant, so devastatingly effective, that they've become the stuff of industry legend, and the primary battlefield for every great entertainment lawyer. To understand this, let's imagine a young, fiercely talented singer-songwriter. Let's call her Maya. Maya has been grinding for years. Open mic nights, posting songs online, building a small but passionate following. One day the email arrives. A major label wants to sign her. They fly her to Los Angeles, sit her down in a glass-walled office overlooking the city, and slide a thick contract across a mahogany desk. They tell her this is her moment, and they offer her a $1 million advance. $1 million. Feels like winning the lottery. It's validation. It's freedom. It's the end of all her financial worries. Her first instinct is to grab the pen and sign before they change their minds. But she remembers a piece of advice she got from a mentor. Never ever look at a contract without a lawyer. So, she hires a seasoned entertainment attorney. Let's call him Ben. Ben doesn't see a golden ticket. He sees a labyrinth. He takes the contract back to his office, and the first thing he does is explain the brutal truth about that $1 million advance. He tells Maya, "This isn't a gift. It's not a salary. It is the most dangerous loan you will ever take out in your entire life. This is the first and most critical lesson of the record deal. The advance is 100% recoupable. This means the label is loaning Maya that $1 million against her future earnings. She will not see a single penny in royalties from her music until she has paid back every last cent of that $1 million. But it gets so much worse. Ben turns the page and shows her the section on recoupable expenses. Because it's not just the $1 million advance she has to pay back. The label is also going to front the money for recording the album. Studio time, famous producers, session musicians, mixing, mastering, let's say that costs $500,000. That $500,000 gets added to her debt. Now she owes the label $1.5 million. Then the label fronts the money for marketing and promotion. Music videos, ad campaigns, radio promoters, press agents. This is non-negotiable if you want a hit. Let's say they spend another $500,000 on that. Now Maya, our brand new artist who hasn't even released a song yet, is $2 million in debt to her own record label. Her $1 million prize vanished before she could even touch it, eaten up by the very machine that's supposed to be making her a star. She is what the industry calls in the red. And the only way out is to sell a staggering number of albums. So how does she pay it back? Through royalties, right? This is where Ben shows Maya the second great trap, the royalty rate. The contract offers her a 16% royalty. That sounds okay. If a song download costs $1, she gets 16 cents, right? Wrong. Ben pulls out a calculator and begins a masterclass in label mathematics, a kind of creative accounting that would make a Wall Street banker blush. First, he explains that 16% isn't based on the retail price. It's based on a wholesale price, which is already much lower. Then the label starts making deductions. There's a packaging deduction, typically 25% of the royalty base, a holdover from the days of vinyl and CDs, even though her music is being streamed digitally. Poof, a quarter of her potential earnings is gone. Then there are free goods. The label gives away promotional copies to radio stations and press, and they deduct the royalties for those from the artist's share, as if she had sold them. Then there are deductions for new technology formats, and reserves held against returns. By the time Ben is done with the math, Maya's 16% royalty has been whittled down to maybe 8 or 9 cents on the dollar. So let's do the math. To pay back her $2 million debt, earning just 8 cents per sale, Maya needs to sell 25 million songs. 25 million. Just to get back to zero. Just to break even. Anything less and she makes nothing, while the label, which takes the other 92 cents of that dollar, is making a fortune. She could have a platinum album, be a household name, be all over the radio, and still be flat broke and in debt to the company that she made rich. This is the moment Maya's dream turns into a potential nightmare. And this is where the lawyer transforms from an advisor into a warrior. Ben's job isn't just to explain the contract. It's to rewrite the rules of the game. He goes back to the label and starts fighting. He argues to cap the recording budget. He negotiates to make only 50% of the video and marketing costs recoupable, forcing the label to have some skin in the game. He fights to eliminate the packaging deduction for digital sales. He claws back every percentage point of the royalty rate he can. He is building a shield word by word, clause by clause. But then he gets to the most important part of the entire contract. The one that isn't about money, but about something far more valuable. Ownership. Buried in the dense legal text is a phrase. Work for hire. This simple phrase means that the label will own the master recordings of Maya's songs. Not for 5 years. Not for 20 years. Forever. In perpetuity throughout the universe. Ben explains that the master recording is the definitive, original version of a song. It's the actual asset. Owning it is like owning the deed to a house. You control who can use it, license it for movies, TV shows, or commercials. It's the source of generational wealth, and the label wants to own it forever. Maya is just the person they hired to create their property. This is the fight that has defined modern music history. The very battle Taylor Swift waged so publicly. It's the difference between being a creator and being a contractor. A good lawyer like Ben will fight for a reversion clause, a legal mechanism where the ownership of the masters reverts back to Maya after a set period, say 20 or 25 years. This is one of the single most important things an entertainment lawyer can do for a musician. It ensures that, eventually, the artist will own their own life's work. After weeks of brutal back-and-forth negotiation, Ben has reshaped the deal. It's not perfect, but it's fair. The debt is manageable, the royalty is better, and there's a light at the end of the tunnel for Maya to one day own her own music. He protected her. But just as Maya is about to breathe a sigh of relief, Ben points to a final section of the contract. He tells her, "This is the old model. It's bad enough." But in the last 20 years, with album sales plummeting, the labels invented something new. Something far more ambitious. Because they realized, why just own the music? Why not own a piece of everything? The touring, the merchandise, the book deals, the acting gigs. Why not own a piece of the artist themselves? This new, all-encompassing contract would come to be known as the 360 deal, the all-around deal. And in the early 2000s, it became the music industry's weapon of choice for survival. To understand why this happened, you have to remember what the world was like back then. The entire foundation of the music business, selling physical copies of music, was crumbling. An entire generation was suddenly being taught by platforms like Napster, Kazaa, and LimeWire that music was free. CD sales, which had propped up the lavish, skyscraper-sized budgets of major labels for decades, fell off a cliff. From 2000 to 2008, album sales in the United States were cut in half. Imagine half your company's revenue just vanishing. It was an extinction-level event. The labels were panicking. They were bleeding money, and the one thing they knew how to sell, the shiny plastic disc, was becoming a relic. So they looked at their artists, these charismatic, multi-talented individuals, and they had a revelation. The CD might be dying, but the artist was more valuable than ever. The artist was a brand, and a brand has multiple revenue streams. The real money wasn't just in the recording anymore. It was in the concert tickets. It was in the face on the t-shirt. It was in the perfume deal, the movie role, the autobiography. The labels realized they had been funding the creation of these massive money-making brands, only to watch all that ancillary income flow to the artist and their team. They were paying to build the rocket, but someone else was getting rich selling tickets to the moon. The 360 deal was their solution. The pitch to a new artist sounded something like this. "We're not just a record label anymore. We are your partner, your brand manager. We will invest millions in you, not just to make an album, but to build your entire career. We'll connect you with tour promoters, with merchandise companies, with Hollywood agents. We are going to make you a star in every sense of the word. And because we're taking on all that risk and providing all that infrastructure, we deserve a small piece of the pie from all of those ventures we help you build." It sounds almost reasonable, doesn't it? A partnership. But the devil, as always, is in the details. And this is where an artist without a savvy entertainment lawyer gets absolutely destroyed. Let's create a hypothetical artist. Let's call her Chloe. Chloe is a brilliant 19-year-old singer-songwriter. A label loves her, and they offer her a 360 deal. On the table is a $1 million advance. $1 million. To a teenager who has been playing in coffee shops, this is life-changing money. Feels like she's won the lottery. She signs. Her lawyer, if she had a good one, would have immediately explained that the $1 million advance isn't a gift. It's a loan. A loan that she has to pay back to the label before she sees another penny from record sales. And it's recoupable against her artist royalty rate, which is, say, 15%. But here's the kicker. That $1 million isn't just for her to live on. It's used to pay for everything. The recording studio time, the producers, the session musicians, the mixing and mastering engineers, the music video director, the marketing team, the radio promoters. Before she knows it, that $1 million is gone, spent on creating and promoting her debut album. And now she is $1 million in debt to her label. But that's okay because she's going on tour. The tour is a huge success. The gross is $2 million. Amazing. Chloe feels like she's on top of the world. But let's look at the 360 contract she signed. It says the label gets 20% of her gross touring revenue. Not the profit, the gross. So, right off the top, the label takes its cut, $400,000. Now, from the remaining $1.6 million, Chloe has to pay for the tour bus, the road crew, the lighting rig, the sound system, the venue fees, the insurance, and her band. Let's say those expenses total $1.2 million. That leaves $400,000. From that, she has to pay her manager 15%, $60,000, and her agent 10%, $40,000. Now she's left with $300,000. And from that she has to pay taxes. After everything, this massively successful $2 million tour might only put about $150,000 in her actual pocket. Meanwhile, the label, which did little more than make a few phone calls, just pocketed $400,000 tax-free, which they can use to pay down that $1 million debt she owes them. It doesn't stop there. Her merchandise sales at the concerts bring in another $500,000. The label's 360 deal gives them 30% of that, so they take another $150,000. She gets an endorsement deal with a fashion brand for $200,000 because her album is so popular. The label takes 20% of that, another $40,000. She co-writes a hit song for another artist. The label gets a piece of her songwriting royalties too. Every single dollar that flows towards Chloe has the label's hand out, taking a piece. At the end of a year where she has been on magazine covers and generated nearly $3 million in economic activity, she might find that she has barely made any money, and she is still hundreds of thousands of dollars in debt to the very company that is supposed to be her partner. This is the gilded cage of the 360 deal. It's a system designed to make it almost impossible for an artist to get out of debt, ensuring the label maintains financial control. So, where does the lawyer come in? The entertainment lawyer is the shield. They are the one person in the room whose only job is to protect the artist from this exact scenario. When that 360 deal first lands on their desk, they don't see a partnership. They see 100 potential traps. And they go to war. First, they attack the percentages. 20% of gross touring? Absolutely not. We'll offer you 10% of the net profits. You don't get paid until my client gets paid. This single change from gross to net can mean the difference between an artist making a living and going into debt on their own tour. Second, they fight over the scope. They build a fence around the artist's money. Okay, you helped us build the touring business so you can have a small piece of that. But you have nothing to do with my client's acting career. We're carving that out. You have nothing to do with the book she wants to write one day. That's carved out. You want a piece of merchandise? Fine. You can have a percentage of the merch we sell at venues on the tour you help promote. You do not get a piece of the merchandise we sell from her website. That's ours. Third, they negotiate thresholds. A good lawyer will argue, you shouldn't be participating in this income at all until my client is making a decent living from it. They might negotiate a term that says the label gets $0 from touring until the artist has personally earned, say, $100,000 from it in a given year. This ensures the artist can actually pay their rent before the label starts taking its cut. And finally, the masterstroke, the sunset clause. A sharp lawyer knows that a contract shouldn't last forever. They will negotiate a clause that states the label's right to participate in these non-record income streams. The 360 rights expires after a certain period. For example, the clause might say the label's participation ends 5 years after the contract term is over. Without this, an artist could be 60 years old headlining arenas and still be forced to send 20% of their tour profits back to the label they signed with when they were 19. The sunset clause ensures that eventually the artist gets to own their career free and clear. This negotiation is a brutal, high-stakes battle of inches. It's about turning a contract designed for corporate profit into one that allows an artist to build a sustainable career. The lawyer's job is to foresee a future the young artist can't possibly imagine and to protect them from it. But even when the lawyer wins this financial battle, another, more personal war is often brewing. Because the 360 deal cemented the idea that the label wasn't just in business with the artist, they owned a piece of them. And when you own something, you feel entitled to control it. The fight over money was just the beginning. The next fight would be over the art itself. This fight over creative control is, in many ways, more brutal than the fight over money. Money is transactional. You can earn more of it. But your art, that's your legacy. It's your voice. To have that voice silenced, twisted, or locked away by the very people who promised to amplify it, that's a different kind of prison. And no one understood this better than the artist who literally changed his name to escape it. To understand the war for creative freedom, we have to talk about Prince. In the early 90s, Prince was a global phenomenon, a creative supernova. He wasn't just making music, he was inhaling and exhaling it. He had a legendary vault, a mythical archive containing thousands of unreleased songs, enough material for dozens of albums. He was working at a pace that was simply superhuman, and his label Warner Brothers had a massive problem with that. It wasn't that the music was bad, it was that there was too much of it. The label's business model was built on scarcity. You release a masterpiece like Purple Rain, you tour it for 2 years, you milk every single, you let the anticipation build, and then you release the next one. But Prince didn't operate on a marketing schedule. He operated on inspiration. He wanted to release a triple album, a jazz-funk side project, a ballet score all at once. Warner saw this as flooding the market, devaluing the brand and cannibalizing sales. They told him to slow down. They refused to release his work. And in doing so, they invoked one of the most powerful and soul-crushing tools in a record contract: the delivery and release schedule. See, a contract obligates an artist to deliver a certain number of albums, but it only obligates the label to release a fraction of them, on a schedule of their choosing. Anything extra you create, it belongs to them. They paid for the studio time, remember? It was all recoupable. So all that music, all that genius Prince was pouring out, went straight from his studio into the label's vault. A vault they owned and they controlled the key. He was creating masterpieces that he himself was not allowed to share with the world. He felt like he was working on a plantation. His creativity was being harvested, but he didn't own the fruits of his labor. This is where an entertainment lawyer earns their keep, not in the courtroom, but in the negotiation room, years before a crisis hits. A sharp lawyer fights tooth and nail over this specific language. They'll argue for a release commitment, a clause that forces the label to release what the artist delivers. They'll fight to define the release timeline, so the label can't just sit on an album for 3 years. They're building an escape hatch before the room even catches fire. But Prince's deal was from an older era. He was trapped, so he did something unprecedented. He went to war, publicly. He appeared with the word slave written on his cheek. It was a shocking, controversial statement. He was telling the world that this multi-million-dollar contract was a form of bondage. Then in 1993, he announced he was changing his name to an unpronounceable symbol, a love symbol. It was widely seen as an act of artistic eccentricity, maybe even career suicide. But it was a calculated legal maneuver. His contract was with Prince. The person who recorded for Warner Brothers was Prince. By killing off his own name, he was attempting to become a new legal entity, one who wasn't bound by that contract. He was trying to sever the connection between the man, the artist, and the corporate asset the label believed it owned. He was essentially telling Warner, "You can own Prince. He works for you. But I am not him." This battle raged for years. The label released albums from the vault under the name Prince, while the artist, now known as the artist formerly known as Prince, released new music independently. It was a messy, public, and incredibly expensive divorce over the custody of his own creativity. And this isn't just a music industry problem. This fight happens in every creative field. In Hollywood, it's the battle for final cut. Most directors deliver their film to the studio, and the studio has the right to re-edit it however they see fit. They can cut scenes, change the ending, add a different soundtrack, all to make it more marketable. A director can see their vision completely butchered and have no power to stop it. Only the most powerful directors, the Spielbergs and the Nolans, have the contractual leverage to demand final cut. Their lawyers negotiate it as a non-negotiable term. For everyone else, their lawyer's job is to build in as many protections as possible. Consultation rights, a limited number of studio edit notes, the right to a director's cut for the home video release. They fight for every inch of creative ground. For a YouTuber or a TikToker today, the same fight happens when you sign a big brand deal. The contract will have an approval clause. The brand wants approval over your script, your jokes, the final edit. Suddenly, your authentic voice, the very thing that built your audience, is being filtered through a corporate marketing department. They'll tell you a joke is too edgy, a topic is off-brand, or that you need to hold their product up to the camera for 3 more seconds. A good creator-side lawyer sees this coming. They'll negotiate the terms of that approval. They'll limit it to 1 round of notes, or specify that the notes must be reasonable and consistent with the creator's established style. They'll make sure the brand can't kill a video for a subjective reason, forcing the creator to waste weeks of work. They protect the creator's relationship with their audience from being hijacked by a sponsor. The legal language that governs this is often buried in dense paragraphs, using seemingly harmless phrases that are actually legal landmines. One of the most notorious is the commercially and technically satisfactory clause. The contract says you have to deliver an album, or a film, or a series of videos that is commercially and technically satisfactory. Sounds reasonable, right? But who gets to decide what that means? The company paying the bills. It's a subjective standard that gives them a nuclear option. If they don't like your new creative direction, if they think your album won't sell, they can just declare it commercially unsatisfactory. They can refuse to release it, refuse to pay you the rest of your advance, and still own everything you created. You're left in limbo, unable to release the work and contractually obligated to keep trying to deliver something they deem satisfactory. It's a creative prison. To fight this, a lawyer will try to tie the standard to something objective. For instance, the new album must be of a quality consistent with the artist's previous albums. This prevents the label from suddenly changing the rules because a new executive took over who happens to hate your genre of music. And then there's the final cage they build around your art, the re-recording restriction. This clause is in nearly every record deal. It says that even after your contract is over, you are forbidden from re-recording any of the songs you delivered to the label for a specific period of time, often 5 to 7 years after the contract ends, or 2 years after the original recording was released, whichever is later. This is the exact clause that forced Taylor Swift to wait. The label owns the master recording, the original version. The re-recording restriction prevents the artist from creating a new, competing master that they would own themselves. It ensures the label's asset remains the definitive and most valuable version for as long as possible. A lawyer can't always eliminate this clause, but they fight like hell to shorten the time period, giving the artist a pathway to eventually reclaim their own work. Losing the fight for money hurts your wallet, but losing the fight for creative control? That attacks your identity. It's the difference between being an artist and being a content provider. It's the difference between having a voice and being a puppet. The lawyer's role is to ensure that when an artist signs on the dotted line, they are signing a partnership, not a surrender. But even if you manage to protect your money and your art, there's one more asset the system is designed to take from you. An asset that becomes more valuable the more famous you get. Your own name. The battle for your brand, your image, and your very identity is often the most complex fight of all. The battle for your brand, your image, and your very identity is often the most complex fight of all. And no artist in history exemplifies this battle more than Prince. In the early 90s, he was one of the biggest stars on the planet, but he was locked in a bitter war with his label Warner Brothers. He felt they had shackled him, owning his master recordings and, by extension, his past. But they also laid claim to the one thing he felt was truly his name. So, in a move that baffled the world, he abandoned it. He became an unpronounceable symbol, forcing the media to refer to him as the artist formerly known as Prince. This wasn't just an eccentric act of a rock star. It was a declaration of war. It was a legal masterstroke designed to reclaim his identity from a system that believed it could own a human being's name like it owned a patent for a toaster. This is the high-stakes world of intellectual property that goes beyond copyright. This is about trademarks and the right of publicity, the two legal pillars that protect an artist's very essence. You might think your name is just your name, but in the entertainment industry, your name is a brand. It's a trademark. The name Taylor Swift is not just a person. It's a global commercial enterprise. The logo for the Rolling Stones isn't just a cool drawing. It's a trademark worth hundreds of millions of dollars. An entertainment lawyer's first job in building an artist's career is to secure this foundation. They will immediately file to trademark the artist's name, their band name, their logo, any signature catchphrases, across multiple categories, from recorded music and live performances to clothing and fragrances. Why? Because if you don't, someone else will. Or worse, the corporation you sign with will try to own it for you. Buried deep in the boilerplate of those early contracts we talked about, there can be a clause that transfers ownership of the artist's brand identity to the label for the duration of the contract. The label's logic is simple. We are investing millions to make the name John Doe famous. Therefore, we should have a stake in the value of that name. Your lawyer's job is to find that clause, strike it out, and replace it with language that says unequivocally the artist owns their name, their likeness, and their brand in perpetuity throughout the universe. The artist is licensing their services to the label, not selling their identity. It's the difference between being an employee and being an indentured servant. This is where another powerful legal concept comes into play: the right of publicity. In the United States, this is the right of an individual to control the commercial use of their name, image, likeness, and other unequivocal aspects of their identity. It's the reason a company can't just slap a picture of Beyoncé on a soda can without paying her. It's a right protected on a state-by-state basis, with states like California and New York having the most robust laws. This right is the legal firepower that allows an artist to build a commercial empire around their fame. But like any right, it's only as strong as your ability to enforce it. This is where the lawyer transitions from a dealmaker to a brand guardian. They set up systems to monitor the marketplace for infringements. Is a t-shirt company in another country selling unauthorized merchandise with your face on it? The legal team sends a cease and desist letter. Is a small company using your song in a social media ad without permission? That's not just copyright infringement. It's a violation of your right of publicity, and the damages can be even higher. They are protecting the brand from dilution and ensuring that every single time the artist's identity is used for commercial gain, the artist is the one who benefits. And the benefits are staggering. The real money in entertainment is often not in the art itself, but in the monetization of the brand built by that art. This is the world of endorsement deals. A sneaker company doesn't pay a basketball player millions of dollars because he's good at negotiating contracts. They pay him because his name and image, his brand sells shoes. The same goes for musicians, actors, and creators. An entertainment lawyer is the architect of these massive deals. They negotiate every single term. How much is the fee? Is it a flat payment, a percentage of sales, or an equity stake in the company? What is the scope of the endorsement? Can the company use your image on billboards, television, social media? Is it for North America only? Or is it a global deal? How long is the term? 1 year? 5 years? In perpetuity? Each of these questions is a minefield. A lawyer will fight to limit the scope and the term, ensuring the artist can renegotiate for more money as their fame grows. They will build in protections. What if the company goes bankrupt? What if the product is a flop and damages the artist's reputation? The lawyer ensures there are exit clauses. But perhaps the most fascinating and fiercely negotiated part of any modern endorsement deal is the morals clause. This is a clause that allows the company to terminate the deal and claw back their money if the artist brings the brand into public disrepute, contempt, scandal, or ridicule. In the age of social media and cancel culture, this clause is a weapon. An old, forgotten tweet, a misspoken comment in an interview, a messy public breakup. Any of it could be used to trigger the clause, costing the artist millions. A skilled lawyer will fight this clause tooth and nail. They will narrow its definition, making it apply only to actual criminal convictions, not just public outrage. They will insert a cure period, giving the artist a chance to rectify the situation through a public apology or other means before the deal is terminated. They will even negotiate a reverse morals clause, allowing the artist to exit the deal if the company engages in scandalous behavior, like an environmental disaster or a labor scandal, protecting the artist from being associated with a toxic brand. This isn't just about money, it's about control. It's about ensuring that a lifetime of building a positive public image isn't destroyed by a single mistake or worse, by a corporation looking for an excuse to get out of a deal. From Prince changing his name to fight for his soul, to a modern YouTuber negotiating the morals clause on their first sponsorship deal, the principle is the same. Your name, your face, your reputation. These are not just personal attributes. They are your most valuable business assets. The art you create makes you famous, but the brand you build makes you wealthy and gives you power. The lawyer's ultimate role is to build a legal fortress around that brand, ensuring that you, the creator, are the only one who holds the keys to your own identity. So you've protected your music, you've protected your name, your fortress seems impenetrable. But what happens when the one person you're supposed to trust, the person managing your career, is the one stealing from you? The enemy isn't always a corporation. Sometimes they're sitting right across the table. This is a story that happens far too often in the shadows of Hollywood and Nashville, in the bedrooms of YouTubers and the studios of Twitch streamers. It's the story of absolute trust and devastating betrayal. It revolves around a legal principle that is the sacred, beating heart of the relationship between an artist and their manager: fiduciary duty. That sounds like a boring $2 legal phrase, but it is the single most powerful weapon you have when the person you trust most becomes your greatest threat. Imagine a young singer-songwriter. Let's call her Chloe. After years of playing in coffee shops and uploading videos to a small but loyal following, she's discovered a charismatic manager. Let's call him Marcus. Sweeps in. He sees her potential. He promises her the world, and for a while he delivers. He gets her a meeting with a label, he books her on a small tour, he gets her music some radio play. Chloe is ecstatic. She's living her dream, and Marcus is the one who made it possible. She trusts him implicitly. He tells her, "You focus on the art, I'll handle the ugly business stuff." And so she does. She signs a management agreement without a lawyer, because Marcus says lawyers just complicate things and eat up money they don't have yet. He'll take a standard 15%. All the money from the shows, the merch, the advances, it all flows into a single business account that Marcus controls. He pays her a salary, a comfortable one, and tells her the rest is being reinvested into her career, marketing, PR, high-end production. It all makes sense. She sees the glossy magazine photos. She hears the polished tracks. The investment seems real. But then, small things start to feel off. A tour that was supposedly sold out barely breaks even, according to Marcus. A merchandise line that fans are raving about online is showing a loss. When Chloe asks for a detailed breakdown of the finances, Marcus gets defensive. He patronizes her. "Honey, you don't understand profit and loss statements. This stuff is complex. Just trust me. When have I ever steered you wrong?" He makes her feel naive, ungrateful even for questioning him. So she backs off, embarrassed. The breaking point comes a year later. Chloe is talking to a bassist who toured with her. The bassist mentions how much he got paid for the tour. Chloe does the math in her head, and her blood runs cold. The number is 3 times what Marcus told her he paid the band. The tour expenses he showed her on a spreadsheet were fiction. They were inflated. Where did that money go? This is the moment the dream shatters. With a knot in her stomach, she finally does what she should have done from the beginning. She calls an entertainment lawyer. She's not looking to sue, not yet. She just wants to understand. She wants an audit. The lawyer brings in a forensic accountant, a kind of financial detective, and what they uncover is a systematic, cold-blooded betrayal. Marcus hadn't just inflated a few expenses. He had created a shell company, a fake PR firm, and was paying that company, paying himself hundreds of thousands of dollars of Chloe's money for services that were never performed. He was taking his 15% commission, and then taking kickbacks from promoters on the side. He was using Chloe's money to pay for his mortgage, his car, his vacations. He wasn't reinvesting in her career. He was liquidating it to fund his lifestyle. This is a catastrophic breach of fiduciary duty. Let's break that down. A fiduciary is someone who has a legal and ethical obligation to act in the best interest of another person. A manager is a fiduciary to their artist. This isn't just a pinky promise to be a good guy. It is the highest standard of care recognized by the entire American legal system. It means your manager must place your financial interests above their own. Always. No exceptions. This duty includes several key obligations. A duty of loyalty, meaning they can't have conflicts of interest like, say, managing a rival artist without telling you. A duty of care, meaning they have to act competently and not be negligent. And, crucially, a duty of accounting, meaning they must be completely transparent with your money and be able to show you where every single penny went. Marcus didn't just breach this duty. He took a sledgehammer to it. And this is where the entertainment lawyer transforms from an advisor into a warrior. The first move is to terminate the management agreement immediately, citing these massive breaches. The lawyer sends a scathing letter demanding a full and complete accounting of all funds, and the preservation of all financial records. This freezes Marcus in his tracks. He can no longer touch her money or act on her behalf. Then the lawsuit is filed. And it's not just for the money Marcus stole. It's for much more. First, there's a claim for disgorgement. This is a beautiful legal concept. It means that because Marcus was fraudulent in his duties, he isn't entitled to any of the commissions he ever earned from Chloe. Not a single dime. He has to pay it all back. Second, there are punitive damages. This is money awarded not just to compensate Chloe, but to punish Marcus for his malicious behavior and to deter others from ever doing the same thing. The goal is to make him hurt financially for his betrayal. Now, you might be picturing a dramatic courtroom scene, but the reality is that the lawyer's most important work is done behind the scenes. Armed with the damning report from the forensic accountant, the fake invoices, the hidden bank transfers, the shell company records, the lawyer has all the leverage. They present this mountain of evidence to Marcus's attorney. The message is clear. We can settle this now, or we can go to court where this all becomes public record, and your client will not only lose, but will likely face a criminal investigation for fraud and embezzlement. Faced with total annihilation, Marcus almost always settles. He agrees to pay back a significant portion of the stolen money, to forfeit all his commissions, and to sign a non-disclosure agreement, vanishing from Chloe's life forever. Chloe gets a check, but more importantly, she gets her freedom and a very, very painful lesson. So how do you prevent this from ever happening to you? This is where an entertainment lawyer's true value lies. Not in fighting the war, but in building the defenses so the war never starts. When you first sign with a manager, a lawyer will draft or review the contract with clauses specifically designed to prevent this kind of abuse. They'll insist on a key person clause, ensuring that if your specific manager leaves the company, you can terminate the deal. They will demand that all your earnings go into a separate, joint bank account that you have full access to and visibility on. They will require quarterly or even monthly financial statements, prepared by a neutral third-party accountant. They will build in a clause that gives you the right to audit your manager's books, at their expense if a significant discrepancy is found. This isn't about distrust. It's about professionalism. It's about creating a system of checks and balances that protects both you and the honest manager. A good manager will welcome this transparency. They want you to feel secure. The ones who push back, the ones who say lawyers just complicate things, those are the ones you need to run from. Your lawyer acts as your professional skeptic, your financial watchdog, ensuring that the person handling your career is held to the highest possible standard. They turn that sacred principle of fiduciary duty from an abstract idea into an ironclad, enforceable reality. They ensure that the person sitting across the table from you is your partner, not your predator. But financial predators are just one type of threat. What happens when the thing being stolen isn't your money, but the very essence of your creativity? What happens when a global corporation takes your idea, your character, your world, and calls it their own? This is the creator's ultimate nightmare. It's one thing to have your wallet stolen. It's another thing entirely to have your soul stolen. To pour your heart, your mind, your wit into a unique creation, only to see it plastered on billboards and movie screens, with someone else's name on it, while they cash checks for hundreds of millions of dollars. This isn't a hypothetical fear. It's a foundational story of Hollywood, a cautionary tale that echoes in every writer's room and pitch meeting. And it's the story of a Pulitzer Prize-winning columnist named Art Buchwald, and a little movie you might have heard of called Coming to America. In the early 1980s, Art Buchwald was a giant. His satirical columns were syndicated in over 500 newspapers. He was a household name, known for his sharp, funny takes on politics and culture. And he had an idea. A brilliant, simple, high-concept movie idea. He wrote a 2.5-page story treatment he called King for a Day. It was about a fabulously wealthy and pompous African prince who is deposed, travels to the United States, and ends up in the ghetto of Washington, D.C., where he falls in love with a government worker. It was a classic fish-out-of-water comedy with a satirical edge. In 1982, through his producer, Buchwald pitched this story to Paramount Pictures. Paramount loved it. They saw the potential immediately. They optioned the story, meaning they paid Buchwald a small fee for the exclusive right to develop it into a film for a set period. They even attached the biggest comedy star on the planet at the time, Eddie Murphy, to the project. For a while it seemed like a sure thing. But Hollywood is a fickle place. The project stalled. Development dragged on. And eventually, Paramount abandoned it, telling Buchwald the script wasn't working and they were no longer interested. The option expired. For Art Buchwald, the story was over. Until it wasn't. Fast forward to 1988. The posters are everywhere. The commercials are on every channel. A new blockbuster comedy is about to be released, starring Eddie Murphy. It's about a wealthy, pampered African prince who travels to America, not to a ghetto, but to Queens, New York, to find a wife and experience life as a commoner. The movie was called Coming to America. Buchwald watched the film and was stunned. The core concept, the central character, the entire comedic engine of the story, it was his. Sure, details were changed. DC became Queens. The reason for the journey shifted slightly, but the DNA was identical. Paramount had taken his idea. They had waited for their legal rights to expire, made a few cosmetic changes, and produced it without him, cutting him out of the picture entirely. The film went on to become a colossal success, grossing nearly $300 million worldwide. And Art Buchwald got nothing. This is the moment where 99% of creators would have to give up. How do you fight a titan like Paramount Pictures? They have armies of the most expensive lawyers in the world. But Art Buchwald wasn't just any creator, and he made a call to his entertainment lawyer, Pierce O'Donnell. And what followed was one of the most important legal battles in Hollywood history. Now, you might think this is a straightforward copyright infringement case. He wrote it, they stole it. But it's far more complex than that. In US law, you cannot copyright an idea. You can only copyright the specific expression of an idea. You can't copyright the idea of a boy wizard who goes to a magic school. But you can copyright a specific character named Harry Potter and his specific story. Paramount's defense was predictable and powerful. We didn't steal Buchwald's script. We developed our own script with our own writers based on an idea from Eddie Murphy himself. Any similarities are purely coincidental or based on a generic, unprotectable idea. Proving they stole the specific expression would be an uphill, nearly impossible battle. But Buchwald's lawyer was smarter than that. He knew the copyright claim was a long shot, so he focused on something else. Something tangible. Piece of paper. The original option contract Buchwald had signed with Paramount back in 1982. And buried in that contract was a single critical sentence. It stated that if Paramount ever produced a movie based upon Buchwald's story treatment, he would be paid a fixed fee plus 19% of the net profits. Suddenly, the entire case changed. The legal question was no longer the impossible to prove. Did you steal the specific expression of my idea? It was the much simpler. Is your movie based upon my original story? The lawyer's strategy was brilliant. He put the contract, not the copyright, at the center of the fight. The trial was a spectacle. O'Donnell's team unearthed a trove of internal Paramount memos, script drafts, and notes that created a clear paper trail. They showed how Buchwald's King for a Day treatment was passed around the studio, how it was the direct inspiration, the seed from which Coming to America grew. After a mountain of evidence, the court reached a verdict in the first phase of the trial. The judge declared that, yes, Coming to America was, in fact, based upon Art Buchwald's story. It was a stunning victory. A single writer had gone toe-to-toe with a major studio and won. Art Buchwald was about to get his 19% of the net profits from a $300 million movie. He was about to become a very, very rich man. Or so he thought. Because this is where the story takes its darkest turn. This is where we learn why the phrase net profits is the dirtiest joke in the entertainment industry. The second phase of the trial began, the accounting phase. Paramount's accountants marched into court with ledgers and binders stacked to the ceiling. They laid out the finances for Coming to America, and they declared with a straight face that despite earning nearly $300 million at the box office, the movie had not made a single dollar of net profit. In fact, according to their books, it was officially $18 million in the red. How is this possible? Welcome to the dark art of Hollywood accounting. The studio, which finances and distributes the film, essentially pays itself first, and it pays itself lavishly. They charge massive, often arbitrary, distribution fees, sometimes 30 to 40% right off the top. They charge marketing overhead, administrative overhead, and exorbitant interest rates on the money they loan to the production itself. Every dollar that comes in is funneled through a labyrinth of internal fees and expenses until the profit column reads zero. It is a system designed by its very nature to ensure that net profit participants never see a dime. Art Buchwald had won the battle over his idea, only to be defeated by a dictionary. His contract promised him a piece of a pie that the studio had defined into non-existence. But his lawyer wasn't done. He went back to court and made a radical new argument. He argued that Paramount's net profit definition was so fundamentally one-sided, so grotesquely unfair, that it was legally unconscionable. An unconscionable contract is one that is so unfair to one party that no reasonable or informed person would agree to it. It's a contract that is so oppressive, the courts refused to enforce it. This was a bombshell. No one had ever successfully challenged the standard studio net profit contract on these grounds. But the judge, looking at the absurd accounting that turned one of the biggest hits of the year into a financial loser, agreed. In a landmark, industry-shaking ruling, the court declared Paramount's contract unconscionable. It sent a shockwave through every studio in town. The very foundation of their business practices had been cracked. Facing a public relations nightmare in the precedent-setting legal ruling, Paramount finally waved the white flag. They settled with Buchwald and his partner for $900,000. It wasn't the tens of millions they were owed based on the film's success, but it was more than a victory. It was vindication. It was a testament to the power of a lawyer who refused to be intimidated, who understood that the fight isn't always about the glamorous world of intellectual property, but often about the mundane, brutal fine print of a contract. He didn't just protect his client's idea, He protected his client from a system designed to exploit him. This case serves as a permanent warning. For every creator, every writer, every YouTuber, every musician, the contract is the battlefield. The definitions of words like gross and net, the specific percentages, the fees, the expenses, that is where your career is made or broken. A great entertainment lawyer doesn't just read the contract. They understand the history behind it, the traps hidden within it, and the strategies needed to fight it. They know that sometimes the most creative work they do is not in a courtroom, but in redlining a single sentence that can mean the difference between a payday and a punchline. The game is still rigged and Hollywood accounting is still a weapon. But because of Art Buchwald's fight, creators now know exactly what they're up against. We've seen how lawyers protect your money and your ideas, but we are entering a new era. A digital frontier with threats that Art Buchwald could never have dreamed of. What happens when the thing being exploited isn't just your work but your face, your voice, your very identity? What happens when artificial intelligence can replicate you perfectly, and a contract you sign today gives a company the right to use that digital ghost of you forever? This is the new frontier, the digital Wild West. And it's the battleground where entertainment lawyers are currently fighting the most important war for artists' rights in a generation. The core legal concept here is something called the right of publicity. In simple terms, it's your right to control the commercial use of your name, your image, and your likeness. If a company wants to use your face to sell soda, they have to ask you and they have to pay you. It sounds simple, but the problem is there's no single federal law for this. It's a patchwork of state laws, which means your rights can change dramatically just by crossing a state line. California and New York have very strong protections, which makes sense, but other states are far weaker. This is why, for decades, lawyers have been fighting cases over celebrity lookalikes in ads or unauthorized merchandise with an actor's face on it. But that was child's play compared to what we're facing now. Artificial intelligence doesn't create a lookalike. It creates a digital twin. A perfect photorealistic replica that can be manipulated to do or say anything. And studios and tech companies are salivating at the possibilities. Imagine a world where a studio can scan an actor once, pay them for a single day, and then own their digital likeness forever. They could put that actor in 10 different movies at the same time. They could make them the star of a video game. They could even resurrect a deceased actor and have them star in a brand new blockbuster, years after their death. For the company, it's the perfect employee. They never age, they never get sick, they never ask for a raise, and they never complain. For the artist, it's an existential nightmare. It's the potential end of their career and the permanent loss of their own identity. This is where the entertainment lawyer becomes an artist's last line of defense. The entire fight happens within the four corners of a contract, specifically in a clause that is now one of the most fiercely negotiated in the entire industry: the digital likeness or artificial intelligence clause. A studio will present an actor with a contract that has a very broad, very vague clause, something like, the company shall have the right to use the artist's likeness by any means now known or hereafter devised, throughout the universe in perpetuity. A young, unrepresented artist might see that and think, okay, sure, whatever. But a lawyer sees a death sentence. Their job is to take a red pen to that clause and dismantle it piece by piece. First, they fight for specificity. They'll change the language from use the artist's likeness to use the artist's likeness as the character of John Smith in this specific motion picture. They'll add language that explicitly prohibits the use of that likeness for sequels, prequels, video games, theme park rides, or commercials without a brand new negotiation and a brand new contract. Second, they fight for consent. The lawyer will demand that the artist, or their estate if they've passed away, must give knowing written consent for every single new use of their digital performance. No blanket approvals. They want the artist to see the script, to see the scenes, to have the power to say no. Third, and this is crucial, they fight for compensation. The studio wants to pay once. The lawyer argues that every time that digital ghost works, the real artist gets paid. If your AI-generated performance is used in a sequel, you get a sequel fee. If it's used in a video game, you get a video game fee and royalties. And finally, they fight for control. What if the AI performance is terrible? What if a de-aged version of you looks creepy and uncanny? What if your digital double is used in a scene that violates your personal moral code? A good lawyer will negotiate for approval rights, giving the artist the power to ensure the final product doesn't tarnish their reputation or their legacy. This isn't theoretical. This was the absolute core of the 2023 SAG-AFTRA actors' strike. The studio's initial proposal was terrifying. They wanted the right to scan background actors, the people who just walked by in the back of a scene, pay them about $200, and then own that scan forever, free to use it in any movie or TV show they wanted without ever paying or asking that person again. It was a plan to create a permanent, non-union digital workforce. The union, led by its lawyers and negotiators, fought back for 118 days, and they won groundbreaking protections, establishing new rules for consent, compensation, and transparency in the use of AI. It was a monumental battle that proved just how high the stakes have become. And this threat extends far beyond Hollywood actors. Think about musicians. AI can now clone a singer's voice with terrifying accuracy. What's to stop a label from generating a new album from a legendary artist without their involvement? What's to stop someone from creating a viral song using a deepfake of a famous pop star's voice? Lawyers are now scrambling to use right of publicity and copyright law to protect the unique quality of a human voice. For YouTubers and influencers, whose entire business is built on their personal brand, their face, and their voice, the danger is immense. Deepfake technology could be used to create videos of them endorsing products they hate, or saying things that could destroy their careers. For authors, AI models are trained on their life's work, and can then be prompted to write a new novel, in the style of that author, diluting their brand and competing with their own books. In every single one of these cases, the fundamental battle is the same: protecting the value of human identity and creativity in the face of a technology that seeks to replicate it. The entertainment lawyer has had to become a futurist, trying to write contracts that protect their clients from technologies that are barely in their infancy. They have to imagine the unimaginable and guard against it with carefully crafted legal language. And in the end, that's what this all comes down to. Throughout this entire journey, we've seen how an entertainment lawyer is so much more than just a person who reads contracts. They are the architect of a creator's career. They are the ones who take a brilliant idea, a song, a script, a YouTube channel, and build a legal fortress around it, protecting it with the armor of copyright and trademark. They are the strategist who navigates the treacherous waters of a record deal or a studio negotiation, ensuring the artist isn't just a cog in a machine, but a true partner in the enterprise. They are the shield that defends a creator from the corporations that would happily chew them up and spit them out, ensuring they get paid fairly, that their rights are respected, and that they retain control over their own work. And now, in this new era, they are the guardians of our very identity. They fight to ensure that an artist's face, their voice, and their soul cannot be digitized, duplicated, and sold off to the highest bidder without their consent. From the first copyright you file to the last complex negotiation over your digital ghost, the entertainment lawyer is the single most important advocate an artist has. They are the ones who ensure that in an industry built on dreams, the dreamer is protected. They champion the simple yet profound idea that your creativity, your name, and your story belong to you, and that no contract, no corporation, and no algorithm can ever take that away.